Welcome to the FloridaDefense.com podcast. With over 30 years of strong defense and over 30 years of even stronger results, with FloridaDefense.com, you'll never believe you can't win.
All right, welcome to the FloridaDefense.com podcast. We are speaking to Tampa Property Crime Charges defense attorney, Mike Kinney. Mike, how are you doing?
I'm doing pretty well. How are you?
Good. We're going to be basically kind of talking about the overall theft today. We've been in the series over robbery and burglary. Mike is with the Bauer, Kreider, and Perry law firm there in Tampa and the surrounding areas. Mike, let's kind of talk about property crimes today.
Well, sure. So what we've been talking about for a while, a lot of it centers around theft, the taking of an item. And in Florida kind of has taken any kind of way you can steal something, whether it be embezzlement, whether it be theft by misrepresentation, and they pretty much put it all under this one statute, and it starts off at 812.014 in Florida statutes, and that's called theft. And it's basically designed to say any time that person takes something knowingly, either permanently or temporarily commits a theft. The statute specifically says a person commits a theft if he or she knowingly obtains or uses or endeavors to obtain or to use, and I'll tell you why that matters in a second, the property of another with the intent to either permanently or temporarily deprive the other person the right to the property or benefit from that property. So that part, endeavors to obtain, that's even an attempt. In Florida, there is no attempted theft. If you attempt to commit a theft, you still fall under that theft statute if they can prove that you endeavored to take something from someone either permanently or temporarily. So that's your basic theft definition. But theft, as you might know, it can vary depending upon the item that is taken. So there's a large variety of ways a person can be prosecuted for a theft. There's two main types of theft. You have your misdemeanor theft, which is called a petty theft in Florida. And then you have your felony theft, which is a grand theft in Florida. And that separating line is the minimum to go from a misdemeanor to a felony is $300 or more. So if a person takes an item that is valued at $300 or more, that person has committed a grand theft, which is a third-degree felony punishable by up to 5 years in prison.
$300.
Mm-hmm.
Wow. Mm-hmm. Okay.
And that amount can change if the item is taken from a home. If the item is taken from a home, it's only $100 to be considered a grand theft. Now, the misdemeanors, there's two types of misdemeanors. There's a first-degree misdemeanor, punishable by up to a year in jail. And then there's a second-degree misdemeanor, punishable by a maximum of 60 days in jail or 6 months of probation. And that is value-specific. Basically, anything under $100 would be a second-degree misdemeanor. Or if a person has a prior theft conviction, no matter what the value is, that you would go from a second-degree misdemeanor to a first-degree misdemeanor. And then, of course, there's a crime called felony petty theft. That means you've been previously convicted of petty theft before, and as a result of that previous conviction, you commit another crime of theft. You have to be convicted 2 or more times in the past, and no matter what the value of the item is, it could be a candy bar. If you've been convicted 2 times before, you get tried with potentially a grand theft charge called felony petty theft.
Okay. Again,
a third-degree felony punishable up to 5 years in prison. Then obviously, we're talking 300, but there's cases that I've handled that we're talking upwards of hundreds of thousands of dollars. When the amount begins to go up, the degree or level of felony begins to go up. So third-degree felonies involve, when I talked about $300 or more, there's certain levels. Levels matter in Florida because levels kind of tell you what kind of points your crime gets assigned, and that's something that's probably a little bit too much detail to get into today. But for generally speaking, a third-degree felony at least is from $300 or more up to $10,000 or more, but less than $20,000. That's the whole scheme of third-degree thefts, and there's a whole bunch of levels in there that assign more points. Obviously the $10,000 or more is going to get a higher amount of points assigned to it. And then you go up from there, but $100,000 or more is where you get into the first degree grand thefts. And those are crimes punishable by 30 years and up to 30 years in prison. And they carry significant levels assigned to them depending upon the amount that almost gives you a minimum. When I say almost, gives you a minimum on the criminal punishing score sheet to where the judge has no discretion if you get convicted of it. So those are your basic schemes of theft. Thefts are very value intense, so it matters what the amount was, and obviously your history intense. If you've been convicted of theft in the past, no matter what the value is, that crime can be enhanced. One of the unique things that I don't think a lot of people know about thefts is that a conviction of a theft, no matter what the value is, can cause a person to lose his driver's license. And that's obviously a concern, especially for people who have been convicted on one or more occasions. But the statute specifically says that the judge may revoke a person's driver's license. Statute 812.0155 says that the court may order the suspension of the driver's license of each person adjudicated guilty of any misdemeanor violation of 812.014, which is a theft, or 812.015, regardless of the value of the property stolen. The court shall order the suspension of the driver's license of each person adjudicated guilty of any misdemeanor violation who has previously been convicted of such an offense. So those are two different statements. The first one says the court may, meaning the court might say an appropriate suspension, appropriate penalty here is a driver's license suspension for a first-time offense. But the next sentence says the court shall order the suspension. That means the court has no discretion. I can tell you that I've handled cases where the court may not have done that, but that's a lot of times the result of a negotiated disposition, perhaps, towards things occur, or whether the court maybe just simply overlooked it. But this statute says the court does not have the discretion. The court shall order the suspension of a driver's license suspension for each person adjudicated guilty if they've got a previous adjudication. So, these can become kind of snowball type offenses. A simple act of stealing something that's very insignificant, maybe doing it a couple of times, and then you get a driver's license suspension, and then you find yourself with no way to get around. I have found that people with suspended driver's licenses tend to drive anyway because they have to.
Yeah.
And then you begin just kind of piling up the misdemeanor offenses until things become much more significant. It's unfortunate.
All right. Anything else on kind of?
Well, we were talking about kind of the levels of theft. There is one avenue of theft that is pretty significant. There's a crime called dealing in stolen property in the state of Florida. And dealing in stolen property is under statute 812.019. And it says any person who traffics in or endeavors to traffic in property that he or she knows or should know was stolen shall be guilty of a felony of the second degree. So this, what that essentially means is, how people buy items occasionally and they know the deal is just simply too good to be true, like a television that fell off a truck. Well, that is potentially a dealing in stolen property charge. The way I typically see it, both as a prosecutor and as a defense lawyer, a person would take an item that he or she knows to be stolen and pawn it at a pawn shop and get money for it. That's usually how these dealing in stolen property charges come up. And what the state would have to prove is that that individual knew that this item was in fact stolen. Well, how do the state usually prove that? Well, because usually they know, or they're able to prove that the person who stole the item is the person who's pawning the item. So obviously if you stole it, you certainly know that it's a stolen item when you take it to be pawned. So I've seen a lot of cases where a person gets arrested for a theft of an item and then pawning that same item at a pawn shop. Okay. Now the difference is a dealing in stolen property is a second-degree felony punishable by up to 15 years in prison. In the state of Florida, even if you've never had a felony conviction before, you don't have any criminal history at all, a second-degree felony requires the court has to adjudicate a person guilty, meaning you're a convicted felon if you're convicted of this particular charge. A grand theft, for instance, or a misdemeanor theft, say you steal a candy bar from a store, that, if you've never been in trouble before in the state of Florida, you get the benefit of what is called, on most cases, a withhold of adjudication. That means this court has not given a formal finding of guilt. And you can say that you have not been convicted of a crime. dealing stolen property, if you're a convicted felon, your life substantially changes. Very difficult to get a job. You can't vote, can't possess a firearm, and life gets a lot harder. If it wasn't hard before, it gets a lot harder to be a convicted felon. So what you see a lot is people steal items and they pawn them, and there's a lot of discussion about, maybe allowing the person to plead to an amended charge or doing something to where they're not a convicted felon if they've really got no prior criminal history. The state of Florida also offers pretrial intervention, which is if the prosecutor handling the case determines that you qualify for a diversion type program where you're not in the court system and the charges later get dismissed, that's a wonderful benefit for folks who've never been convicted of crimes before. The problem is if you get a dealing stolen property charge, it's a second-degree felony, and that's not eligible for a PTI type charge. Of course, a lawyer can try to work to get that changed for you, but dealing stolen property changes a lot when we're talking about a theft charge. The Florida statutes say that a person cannot be convicted of both a dealing stolen property and a theft of the same item. So if a person gets arrested for stealing, a necklace and then pawning it at a pawn shop, and he gets arrested and he goes to trial on it, a verdict cannot be returned as guilty as the theft and the dealing in stolen property. You can only be convicted of one. And usually what happens is the prosecutor picks which one to charge the person with. And in most cases, they pick the highest charge, which is the dealing in stolen property. At least that's been my experience as a prosecutor. So it's almost like playing chess sometimes, and you figure out all these little moves that can happen that can have an impact on the ultimate outcome, which is a person's life.
And that's why you need an experienced Florida defense criminal attorney like you guys, right?
There's no doubt about it. What you don't want when you're talking about your life, when you're talking about your future, what you don't want is someone to do some on-the-job training with you. Mm-hmm. You want somebody who you are confident knows what he or she is doing. And there's only really a couple of ways you get there, right? Any lawyer can tell you he's great. All right, I can tell you I'm a great trial lawyer.
Right.
I can tell you that, but how do you know I'm telling you the truth? Well, one of the ways you know that the lawyer knows what he's talking about is whether or not he is a board-certified criminal trial lawyer. Yeah. That's the highest recognition of a lawyer's skill, competence, and ethics in a particular field. It shows that a lawyer has been in the business and trying criminal cases for a period of time. He's had a minimum amount of criminal trials, tried to verdict, jury trials, had a minimum amount of felony trials, passed a specific rigorous examination designed to show that person can represent himself as an expert in that particular field. So a lot of people can say something, but very few lawyers in the state of Florida, quite frankly, have that distinction of being a board-certified criminal trial lawyer. At my firm, lucky to have me and another lawyer at my firm have that designation.
Great. All right, Mike. Anything else on property crimes?
No, sir.
All right. Well, you've been speaking to Tampa Property Crime Charges Defense Attorney Mike Kinney at the Bauer, Kreider, and Perry Law Firm. Check him out at floridadefense.com.
Thank you for listening to the floridadefense.com podcast. Our firm has over 130 years of combined legal defense experience. Strong defense, stronger results. Consultations are free. Visit floridadefense.com today.